The Supreme Court chamber grew quiet, the kind of silence that hums with anticipation. All eyes turned as Representative Jasmine Crockett stepped toward the podium, her tailored navy suit striking against the deep, polished wood of the courtroom. The faint echo of her heels filled the air as cameras locked in, capturing her poised expression, calm, measured, yet unmistakably confident. You could feel the weight of the moment before a single word was spoken. Just minutes earlier, Justice Stephen Breyer had surprised everyone by cutting off the opposing counsel mid-sentence with a statement no one saw coming. "I'd like to hear from Representative Crockett," he said firmly. Her written arguments were extraordinary. The courtroom stirred. Conservative justices exchanged uneasy glances. Chief Justice Roberts gave a brief, puzzled lift of his brow. But what followed would ripple far beyond those marble walls as Crockett unfolded her notes. Justice Breyer leaned forward, his tone almost admiring. "Congresswoman," he began, "your constitutional interpretation challenges long-held precedent in a way that cannot be ignored. Please, share your reasoning with the bench." Murmurs swept through the gallery. Reporters whispered into recorders. Court officers had to quiet the room. Yet through it all, Crockett stood firm, her composure unshaken. In that moment, she wasn't just defending a case, she was rewriting how the highest court viewed her. Before we unpack this remarkable exchange, make sure to subscribe for continuing coverage of today's most defining political and legal moments. Representative Jasmine Crockett is no stranger to pressure or controversy. Long before she took a congressional seat, she built a fierce reputation in Texas courtrooms as a civil rights attorney unafraid to tackle the impossible. Many of her cases were the kind most lawyers quietly turned down, yet she took them on and won. Her rapid ascent from state legislator to U.S. Congress was fueled by viral clips showcasing her fearless questioning and her rare ability to translate complex legal ideas into plain language that resonated with everyday Americans. But today's hearing was different. This wasn't a rally or a committee exchange. This was the United States Supreme Court, and the case at hand dealt with voting rights restrictions accused of unfairly burdening minority communities, an issue at the very heart of Crockett's career. For weeks, commentators on conservative networks dismissed her involvement, calling her untested and unqualified to stand before the nation's top jurists. "She's just a first-term congresswoman pretending to be a lawyer," one pundit scoffed. Breyer will dismantle her argument within minutes. Yet Justice Breyer, serving what was expected to be his final term, had built his name on deep legal reasoning and practical understanding of how laws affect real lives. Over decades, his questions and decisions had shaped the tone of modern American jurisprudence. But that morning, something about his demeanor was different. Observers noticed his intense focus on Crockett's presentation. Later reports revealed that her submitted brief was heavily marked with his notes, underlines, and handwritten reflections, a rare sign of genuine intellectual engagement. What many didn't realize was that Crockett had spent months perfecting a groundbreaking legal framework, one that challenged recent court rulings on voting rights without openly confronting the conservative justices who authored them. Her strategy was subtle, rooted in forgotten Reconstruction-era doctrines and original constitutional texts. The brilliance of her approach lay in how it reframed old principles through a modern lens. The implications were massive. Millions of citizens' access to the ballot could hinge on the arguments unfolding in that courtroom. A single misstep could allow restrictive laws to stand, shaping elections and representation for a generation. Conservative organizations had filed dense, forceful briefs warning that her position would upend decades of settled law. But inside the courtroom, as Crockett began to speak, even her harshest critics had no choice but to listen. Conservative analysts had labeled her theories risky and untested, even radical. But as Representative Jasmine Crockett gathered her papers, there was a quiet confidence in her movements, the kind that unsettles a room used to control. Justice Samuel Alito leaned subtly toward Justice Clarence Thomas, sharing a whisper that drew faint smiles from the bench. Across the row, Justice Amy Coney Barrett tapped her pen against the table, a soft, rhythmic sound of impatience. Only Justice Breyer's gaze remained steady, eyes fixed on Crockett with the curiosity of someone recognizing brilliance before others did. "Congresswoman Crockett," began Chief Justice Roberts, his tone firm but measured. "You have 30 minutes to make your case. I'll remind you that this court has already ruled on these matters. The precedent stands." Crockett inclined her head slightly. "Thank you, Mr. Chief Justice," she said. "I'm well aware of the precedent. And that, Your Honor, is exactly why I'm standing here today." The tension tightened like a string. What followed would be unlike anything the Supreme Court had witnessed in years. When she began, her voice was even and deliberate, a calm, commanding tone that contrasted sharply with her fiery exchanges in congressional hearings. "Justices," she said, "please turn to Section 2 of the Voting Rights Act. This court previously interpreted it as requiring proof of discriminatory intent, not just discriminatory impact." Her delivery was precise, her phrasing careful, each word landing with the weight of preparation. Justice Alito interrupted almost immediately, his question laced with quiet skepticism. "Congresswoman," he said, "that settled law, reaffirmed just 2 terms ago. Are you suggesting we overturn our own precedent?" His tone carried a trace of condescension. Crockett didn't waver. "No, Justice Alito," she replied smoothly. "I'm asking the court to apply its own standard properly." From her folder, she produced a document that hadn't been part of the main case filings. "This statistical analysis wasn't available during the earlier proceeding," she continued. "It shows that even under your existing framework, the evidence of discriminatory intent remains undeniable, a pattern consistent only when viewed through the lens of race." The air grew thick. Challenging a senior justice so directly was a daring move, and everyone in the gallery knew it. Observers exchanged glances. Was this bold theater, or the makings of a genuine legal turning point? Then, breaking his usual silence, Justice Thomas spoke up. "Congresswoman," he said, "these numbers could support multiple interpretations. What makes yours the correct one?" Before Crockett could respond, Justice Breyer leaned in once again. "Actually, Justice Thomas," he interjected, "the methodology used here is consistent with this court's reasoning in Johnson v. United States, 1987. It's entirely sound." Then he turned back toward Crockett with a small nod. "Please, continue, Representative." It was an extraordinary moment, a senior liberal justice appearing to shield a member of Congress from conservative scrutiny in open court. Reporters scribbled notes at breakneck speed. Something truly historic was taking shape. Crockett pressed forward, layer by layer, building her argument with composure and clarity. Each citation forced the justices to flip through their binders, searching for rulings they hadn't expected to revisit. When Justice Barrett questioned her reading of a 1980s decision, Crockett responded without hesitation, quoting from Barrett's own law review article written years before, one that, ironically, supported Crockett's position almost word for word as stunned silence fell across the chamber. Cameras zoomed in. Even her critics, who had dismissed her as inexperienced just days earlier, had to confront the truth. Jasmine Crockett hadn't just mastered the law, she had reshaped how it could be argued at the highest level of American justice. Crockett began steadily. "In your 2006 publication, you wrote that statistical disparities of this scale create a presumption, one that shifts the burden to the state to demonstrate the absence of discriminatory intent. I'm simply applying that same scholarly principle to the facts before us." For a brief moment, Justice Barrett's expression softened into surprise. She hadn't expected her own academic writing to resurface in this way, not as support for the argument unfolding before her. The realization drew quiet murmurs from the gallery. The air in the chamber felt tighter now. One by one, Crockett addressed the court's conservative arguments, dismantling them piece by piece with the calm precision of a surgeon. She wasn't appealing to cameras, nor was she speaking with outrage or drama. Her tone was measured, analytical, and remarkably composed, every sentence supported by citations and evidence. The method was unmistakable. She wasn't here to perform, she was here to prove. Then Justice Brett Kavanaugh shifted in his chair and took a different line of questioning. "Congresswoman," he said, "even if we accept your statistical findings, doesn't the state retain a compelling interest in preventing voter fraud? These measures appear to be narrowly tailored toward that purpose." It was a calculated move, a question crafted to corner her into sounding dismissive of election security, a theme that would echo loudly in media discussions later that night. The audience fell silent. Sensing the trap, Crockett offered a faint, almost knowing smile. "Justice Kavanaugh, I'm very glad you brought that up," she said, reaching for another folder. "I reviewed every single voter fraud prosecution in this state over the past 2 decades. There were exactly 13 cases," she stated firmly, "and not one of them would have been prevented by the policies under review today." She paused, letting the number hang in the air before continuing. However, these same measures would prevent roughly 740,000 eligible voters from casting ballots. The courtroom absorbed the figure like a thunderclap. "If we're discussing narrow tailoring," she added, her tone steady but pointed, "I would argue that this is the exact opposite." Justice Breyer gave a subtle nod, small, but unmistakable. Across the bench, conservative justices exchanged cautious glances. The energy in the chamber shifted once again as Crockett's allotted time began to run short. Chief Justice Roberts, who had remained silent throughout most of the exchange, finally spoke. His voice carried the calm authority of experience. "Congresswoman Crockett," he said, "your statistical presentation is persuasive. However, this court has traditionally been reluctant to interfere in state election procedures unless a direct constitutional violation is evident." "It was the opening she'd been waiting for, Chief Justice," Crockett replied evenly. "I understand and respect the court's restraint. That is precisely why I've reserved my most significant argument for this moment." She reached into her briefcase and retrieved a carefully bound document, aged, formal, and clearly unfamiliar to the justices. "This," she said, holding it up, "is a newly authenticated transcript from congressional debates during the drafting of the 15th Amendment." A visible wave of interest crossed the bench. Historical records from that period were rare, and anything shedding light on the framers' original intent carried tremendous legal weight. "These are first-hand statements," Crockett continued, "from the amendment's authors, directly addressing the very kinds of state actions we're reviewing today." The justices leaned forward. Even those who had seemed disinterested moments before were now attentive. "This transcript," she said, "was verified by historians at 3 separate universities. It shows clearly that the framers of the 15th Amendment intended to prevent states from erecting procedural barriers that disproportionately burdened newly freed citizens' right to vote, even when those laws didn't explicitly reference race." The chamber was silent again. Justice Breyer slowly leaned toward his microphone. "May I review that document, Congresswoman?" he asked. Crockett nodded. "Of course, Your Honor." She handed the transcript to the clerk, who walked it carefully up the steps to the bench. Every eye in the courtroom followed the exchange, a moment heavy with history, strategy, and the quiet sense that something extraordinary was unfolding before them.
"So, what's the real lesson from Judge Raquel West's courtroom today? It's simple. Excuses don't carry weight here. Only accountability does. The message is firm. Your choices define your outcome. Both Mr. Casey and Miss Allen were given a second chance through probation, but the judge made it clear that even one misstep could send them straight to prison for years. It's a powerful reminder that justice isn't just about punishment. It's about proving you're willing to change. Was Judge West too strict, or did she strike the perfect balance between mercy and responsibility? Share your thoughts below, and stay tuned for more powerful courtroom moments where every verdict tells a story.